What is a DUI? DUI stands for driving under the influence. However, there's a lot of elements to that are not included in the name. The key factor in a DUI is the impairment of the ability to drive. So the general statute for DUI punishes driving or being under physical control of a vehicle while your ability to drive is impaired to the slightest degree, whether it be from consumption of alcohol or drugs. Now, what does this mean? Impairment basically means that driving requires certain tasks to be performed, and consumption of alcohol or drugs can limit your ability to perform those. It may slow you down or just make you make bad decisions, right? That is what is being punished. The fact that after consumption of a drug or alcohol, you actually are impaired to drive. Impairedness to the slightest degree just basically means that any limitation on your ability to drive is enough, as long as it's caused by the consumption of either alcohol or drugs. Another element that people don't really understand is the actual physical control of a vehicle. Sometimes you're just parked on the side of the road, cop comes over, takes you out. Hey, you know what? You got alcohol in your system, you're going to jail. Actual physical control is an issue of fact that usually is left to the jury to decide based on the totality of the circumstances, where you were, how you were sitting, the position in the car, was the car on, was the car off, were you using the car just as a means for shelter, or were you actually in physical control of the vehicle? The key issue in this type of DUI is whether you pose a threat because of your imminent control of the vehicle. It's a difficult issue of fact that's always left to a jury to decide. There's different types of DUIs, but for now let's talk about, there's a drug DUI and alcohol DUI. So the more common one is the alcohol DUI statutes, right? So you have the general statute that talks about impairment to the slightest degree. That means that your ability to drive was affected or limited by your consumption of alcohol prior to driving to the slightest degree. So any type of limitation. The other types of alcohol DUIs are based on the blood alcohol concentration or breath alcohol concentration. They have different machines that will either test your breath and come up with a concentration of alcohol, or they have other machines that would test the concentration of your blood alcohol. In the end, the numbers end up being the same. I won't bore you with the scientific details, but concentrations are 0.08, 0.15, and 0.20. Those statutes don't go into impairedness anymore because it is assumed that anybody with a 0.08 alcohol concentration is impaired. The difference between the three is how much time you're going to get if you're convicted based on minimum mandatory sentencing. A 0.08 DUI, but below 0.15, is just like a general normal DUI. It's just minimum is 10 days, and 9 can be suspended if you do counseling and alcohol evaluation or whatnot, and you basically do a day. That's the same thing if you get impaired to the slightest degree DUI. Now the 0.15 DUI, so above 0.15 or under 0.2, that is what we call an extreme DUI, and the minimum mandatory jail time is 30 days. All but 9 of them can be suspended if you put an ignition interlock in your car. And then the 0.2 or above DUI, that's an extreme DUI, sometimes called a super extreme. That one is a minimum mandatory sentence of 45 days, all consecutive, but all but 14 can be suspended. The extreme DUI statutes have additional assessments, the fines are a little higher and stuff like that. All DUIs will have some type of suspension on your driver's license. Now, let's talk about an aggravated DUI, which is also known as felony DUI. There's some confusion about an extreme and an aggravated DUI. An extreme DUI is what I spoke before about 0.15 or higher. That's what we call an extreme, but those are generally still misdemeanors, right? To have a felony DUI or an aggravated DUI, there's 5 ways of that happening. The first one is you got a DUI while your license was suspended because of a prior DUI. The second one would be you get your third or subsequent DUI. If you go back 7 years and you have 2, and this is your third, that would be a felony DUI. Another way of having a felony DUI is you commit a DUI, no priors necessary, with a minor in the car, somebody under the age of 15. Another way of committing a felony DUI or an aggravated DUI is getting a DUI while you have an ignition interlock placed in your car. And the final, 5th way of committing an aggravated DUI is getting DUI while you're driving in the wrong way on a highway. They're all felonies, all 5 cases. The one where you're driving with a minor, that's a class 6 felony. All the others are class 4 felonies. Now, the relevant penalty for a class 4 felony ranges from 1 year to 3.75 years in prison. If it's your first, you would probably qualify for probation. The problem is, 3 of the aggravated DUI statutes require a minimum of 4 months in prison before you're eligible for probation. If you get a DUI while your driver's license is suspended for a DUI, if you get your third or subsequent DUI, or if you get a DUI while you're driving on the wrong side on the wrong way on the highway, even if you qualify for probation, you gotta do 4 months in prison. So there's other consequences apart from the general fines and jail time or prison time that come with a DUI. The main ones are your driver's license will be suspended from anywhere from 90 days to a year or more, depending on if you're a repetitive offender. And also you have to do some counseling, some substance abuse counseling, stuff like that. And you'll probably be required to get special insurance on your vehicle, which will be more expensive going forward. You will have to deal with this for several years. Now, drug DUI is a little different. There's no like per se number or concentration of a drug that makes you impaired. They have to prove that there was a drug in your body and that drug impaired you, right, to drive, and therefore you shouldn't have been driving, right, and therefore you're gonna go to jail. The more complicated one is when they're charging you with mere presence of a drug or a metabolite. So for example, there's a list of controlled substances in the statute that says if there's any of these substances in your blood, you're guilty of DUI. They do a blood draw, the test comes back, you have meth, you have cocaine. These are in the controlled substance statutes, and that is a DUI that you have presence of the drug. Where it gets a little different is when you're talking about a metabolite of the substance, right? Because the statute says that you can be guilty of DUI if you have cocaine or methamphetamine or a metabolite of that substance. Drugs basically, as soon as they get into your system, start to change. They start to metabolize, right? So they start to change the way they are in your system chemically. So they turn into different compounds. Some of these compounds are impairing, some of them are not. So there was significant litigation, but basically the law is now that not just any metabolite, it has to be an impairing metabolite. For example, I've had cases where a client was charged with a DUI, but the only metabolite was B. It's benzocoaguinine or something like that. It's a weird name. Anyway, that's a general metabolite of cocaine, but it's not impairing. So whilst it is proof that the person consumed cocaine, there is no evidence that the person is impaired to drive. And the DUI statutes don't punish consumption. They punish impairment. So we get those dismissed. I know all this information may be overwhelming, and I understand. It is a lot to digest, but don't be too intimidated by it. Most of, if not all, criminal charges are defensible. It just depends on the facts of your particular case. In all cases, you can get your charges dropped, reduced, dismissed, or even win a trial. But you need an attorney who knows what he's looking for and who's committed to defending your case. I've been doing this since 2009. I got here in Arizona. I've been a lawyer for almost 18 years now, and I've been doing DUI since then. And I've been not only defending DUI, but I've been also prosecuted DUIs. I know what to look for. I know how to attack a DUI. You need an attorney who's committed not only to doing the work, but to your case. And my firm, we're committed to your success. And in order to reach an optimal solution for your case, there's a lot of things we do. First of all, we look at everything that's out there. We see all the evidence. We study it. We make sure and look for everything that the state will have or at least will try to have as evidence for your trial. We identify the weaknesses of that case. We try to remove as much evidence as we can to deny the state all the evidence that they want to present. Because the state wants to win, so they'll want to throw everything at you, but there's rules. So we keep them straight, we keep them honest, and we make sure they don't present any evidence that's unreliable. Secondly, we make sure and find out how to attack the credibility of the state witnesses. Is it a cop? Well, cops aren't perfect. So when there's violation of police procedures, we identify them and we challenge that. We make sure to have everything we can to attack their credibility and show the jury that it's not necessarily true that you were impaired. Usually the state in a DUI will have an expert witness come and testify about, oh yeah, I tested the blood this way or the other way and it's perfect and the guy's guilty of sin. But these experts, all they do is testify for the state all the time. And part of their job is testifying. And as part of their job, their testimony gets monitored by the state, by their boss. I actually had a case where the boss of the expert was in the galley looking at him, seeing what he was saying. So we can bring that out and show the jury, this is a professional witness. He's getting paid to be here. His interest is not truly not truly in the truth. His interest is in his job. I always make sure when I get discovery of blood work on a DUI to get an expert, my expert, to review all that blood work to see what defenses we can present against it. Sometimes there's good stuff there, like there's no separation, that there's confusion as to what the machine read being alcohol being something else. That all helps you raise doubt to the jury whether that's a valid number, right? The UBAC, right? Your blood alcohol or breath alcohol concentration. Another thing we do is we make sure that the prosecutor behaves right. And if he doesn't, we challenge their refusals and we seek sanctions in the form of preclusion of evidence. I've had cases where the state won't give me something. They refuse to disclose. Well, if they won't disclose, they can't use it at trial. So in my firm, we look at everything and we tell you what we find. And we sit down with you, I sit down with you and go through all these things. And you and I decide what's your best choice. I give you the information that you need to make a very important decision in your life. If you or somebody you care about is facing DUI charges in Arizona right now, call me. I'll give you a free consultation and we can discuss your charges and your rights and see if we're the right fit. We're here to help.